We're going to look at indemnification in the context of outsourcing and technology procurement and transitional services arrangements, and in particular whether some types of indemnities actually meet the needs of the business. And we're going to look at that from both the customer and the supplier perspective. Now, as most of you know, indemnities are typically heavily negotiated in contracts, and they are an important mechanism for reallocating loss between the parties. So it's really important to make sure that the indemnity itself meets the needs of the business. So we have seen some cases where sometimes the loss that arises falls outside of the scope of the indemnity and is not recoverable despite the expectations of the parties. Now, Nick, give us an outline of a case where that recently happened.
Yeah, so the first case is this Wood and Capita Insurance, which is a Supreme Court decision upholding the Court of Appeals judgment around the indemnity in a sale and purchase agreement in the context of a sale of an insurance business. It concerned the buyer making an indemnity claim under the indemnity, which broadly provided that the seller was to indemnify the buyer's group for any losses following and arising from complaints or claims made to various insurance regulators for mis-selling of insurance that occurred prior to completion. There was this mis-selling of insurance that occurred prior to completion, and the buyer subsequently made this indemnification claim and also notified the regulator. And the regulator did its own investigation and confirmed that there had been this mis-selling, and then decided that the target company had to implement a remediation scheme to compensate these customers. And so there was this indemnification claim, which the seller rejected, and the seller said that it had not been triggered, and through this various appeals, there had been decided by the Supreme Court that the indemnity had not been triggered, siding with the seller. And their decision was based on the fact that only customers could make claims or complaints to the regulator against the customer, not the self-reporting of these mis-selling by the buyer, even though the clause itself didn't provide for this drafting. The commercial aspect of this is quite important, where the buyer did have a range of warranties that it could claim under, but it was time restricted and had run out of time, and the court wasn't going to step in to improve the buyer's poor bargain. So with this decision in mind, how do you see that working in terms of drafting our indemnities in outsourcing and technology contracts?
So the decision is a timely reminder to the draftsman to take care when considering what risks the indemnity needs to cover and to make sure the drafting reflects that. So in an outsourcing or technology procurement, and occasionally in TSAs, we would expect to see a number of indemnities and a number of different types of indemnity trigger. So for example, a trigger for regulatory breach, or a trigger for data privacy breach, or infringement of third-party IP. And in some cases, you'd expect to see some sort of case or transaction-specific indemnities to deal with the relevant transaction at hand. So if we think about the losses flowing from the issue that was decided in Wood versus Capita, we need to be very clear about the timing of the indemnity trigger. So this may result in drafting around a suspected regulatory breach or investigation by a regulator rather than actual enforcement action undertaken by a regulator. And conversely, a supplier may want a narrower trigger, so it may want the drafting indemnity trigger to be in relation to a substantiated breach or actual enforcement action taken by a regulator as opposed to simply an investigation. So similar thinking can be applied to an indemnity for IP infringement claims. The question for the trigger could be, is it in relation to any alleged intellectual property rights infringement, or does the trigger need to be in relation to any claim that's been finally adjudicated? So in both these cases, we need to be clear about what the trigger is for the indemnified party. Otherwise, they may be left in a similar position to that in Wood versus Capita, where their expectation is that they're covered by the indemnity, but actually they find that the loss they're seeking to recover falls outside of the scope of the indemnity altogether.
So the next case I think is interesting is that of PAGI and Cigna Insurance. And this is a High Court decision which looked at whether a party can be indemnified for its own acts and omissions, again in the context of the sale and purchase of an insurance business. At a high level, the facts of this one is that the buyer agreed to indemnify the seller for any business liabilities that it incurred after the effective date of the sale and purchase agreement. And what happened here was, after completion, there had been identified this mis-selling of insurance by the seller's group, which the seller went to redress by paying compensation to the affected customers, but in turn then turned to this indemnity to claim these business liabilities from the buyer. The buyer rejected this, saying that these types of liabilities weren't those covered by the indemnity, as it wasn't going to cover the seller's group's own negligence. But ultimately, the High Court decided that the indemnity was broad enough to capture those acts covered by the seller's own negligence, excluding fraud and dishonesty based on the context and the language of the clause, even though this wording wasn't expressly provided for. So again, using this decision, how do you see this impacting drafting with indemnities for outsourcing and technology contracts?
Well, it's clear that while the facts and the issues between the Cigna and the Wood versus Capita cases were different, I think the takeaway for businesses is exactly the same, which is that they require clear drafting in the contract to make sure that it's clear what the indemnity is covering. So the question sometimes comes up in outsourcing and technology procurement contracts is whether the indemnified party's own actions should be covered by the indemnity. Now, take, for example, a party that's being indemnified for regulatory breach. The indemnity will cover the costs of that party interacting with the regulator, investigations, hearings, and proceedings. And in conducting that interaction, the indemnified party's behaviour could be such that it incurs additional costs beyond the costs that it should have incurred because it hasn't properly managed that interaction with the regulator. The same can be true, for example, in an intellectual property rights infringement claim by a third party. If the party being indemnified receives the claim and decides to either settle the claim or to defend the claim, its actions in settling or defending the claim, if not properly carried out, could mean that the indemnifying party incurs more cost. And so what we see from those two examples is that the party defending or settling the claim or interacting with the regulator can actually make things a lot worse through its conduct and increase the size of the liability that has to be picked up by the indemnifying party. So simply relying on the absence of wording covering the indemnified party's own acts and omissions may not be enough for the indemnified party to not have to pick up those extra costs and expenses. But Nick, what's your take on that in relation to the Cigna decision?
Yeah, that's interesting because there is the Cigna decision which says that the absence of wording does mean that the indemnity may cover a party's own negligence acts. But there's also earlier authorities which go the other way, saying that without this express wording, the indemnity won't cover a party's own negligence acts. But I think overall, these cases are a timely reminder that each indemnity is interpreted based on its own construction. And because of that, we need to be very careful around drafting these in terms of what losses we expect to be recoverable under them, as well as the trigger for these. Otherwise, you might be left in a situation where both the indemnified party and the indemnifying party are taking on risks that they never appreciated at the time of contract.